All set.
Thank you. So thank you for joining One South Coast Human Resource Council for today's presentation. Attorney Gary Howayeck specializes in employment law and is a member of the board of directors for One South Coast Chamber. We're delighted to have him here today to present his educational seminar. It's definitely not a ceremony. Present his educational seminar on marijuana in the workplace. If you have questions during the presentation, please type them in the chat box and we will moderate them. And after the presentation is over, we will review those questions. So now I will turn it over to Attorney Gary Howayeck to begin his presentation. Thank you, Gary. Welcome.
And Katie, just one quick question. I keep on seeing people to be admitted. You're doing that automatically, correct?
I'm taking care of that. You don't have to worry about that. Yes.
All right. Welcome, everybody. My name's Gary Howayeck, for those who don't know me. Today, we're going to be talking about marijuana in the workplace. And before getting into the meat and potatoes of the presentation, and as people are still checking in, I have some, well, fun facts about marijuana. Marijuana, this is a statistic from 2019, so it's a little dated, but not too dated. In 2019, approximately 50 million people use marijuana at least once. When you think about that, that's 1 in 5 people. So if you have 100 employees, there's a good chance at least 20, and in Massachusetts, statistically, it's higher than that, at least 20 have used marijuana at least once in that year. Now, why is that relevant? Look at bullet number 2. What does marijuana do? Marijuana affects the brain, specifically parts of the brain that's responsible for memory, learning, attention, decision-making, coordination, emotion, and reaction time. So obviously, those are attributes employers want their employees to be on, right? You want your forklift operator to have a good reaction time and make good decisions. So it's a relevant presentation for the obvious reasons, because marijuana has certain effects on the body that do carry over to employment if you recently took marijuana, especially. Now, in 2017, I thought this was a fun fact. The sales of medical and recreational marijuana were nearly 9 times higher than the sale of Oreo cookies. And if you know, every house, for the most part, has Oreo cookies. This shows you how much marijuana was purchased. The average medical cannabis user, and I'm going to use the term marijuana and cannabis interchangeably, meaning the same exact thing. But for medical use, the average person spent approximately $136 every 10 days. And the average recreational user spent approximately $50 every 2 weeks. The last fact here that I'm going to talk about is very sobering when you think about it. Marijuana is the second most frequently found substance in a driver's body after a serious traffic accident. So obviously, employers do care on whether their employees have marijuana in their system. Who am I? I'm Gary Howayeck. I've been practicing law for approximately 25 years. I concentrate my practice in business and employment law. I am also the Assistant Corporation Counsel for the City of Fall River and have served in that capacity since 1998, defending their civil rights claims and their employment claims. My private practice, I represent, about 90% of my practice is employers, where I deal with issues from the hiring to firing, everything in between, including labor issues. I also defend companies at the MCAD, the Massachusetts Commission Against Discrimination, the EEOC, and of course, Superior Court. Superior Court cases such as paid family medical leave, Wage Act issues, and the like. My contact information is down below. After this presentation, assuredly, you're going to have questions that some of you may not feel comfortable with asking through the chat box. Feel free to reach out to me either by call or by email, and I will help you out. Next slide. I'm still learning how to do slides here. This is the rubric of today's agenda. So we're going to be talking about cannabis ABCs, and then we're going to be focusing in on what the federal law entails. The federal law I have broken down in order in the slides: the DOT, Department of Transportation, the DFWA, which is the Drug-Free Workplace Act, and then the Americans with Disability Act. And then under the federal law, the question is, with the Americans with Disability Act, is there a duty to accommodate? Then we're going to talk about the Massachusetts law and the duty to accommodate under Massachusetts law and what that entails. We're going to talk a little bit about drug testing and then policy considerations. So today we are talking primarily about, oh, this is an aside, but interesting. I was talking to a business owner last week at Sog's restaurant, and I asked him, what's your main concern about marijuana in the workplace? And he didn't really have much of a concern other than to tell me his customers don't want to see people high. And I thought that was obvious and also curious. But what he told me, which I thought was more fascinating, is fellow employees don't want to tell on fellow employees. Or I should say employees don't want to tell or tattle on fellow employees. And the reason, he said, is because, well, one, they don't want to be a tattletale. But secondly, if I tell on that person and that person is either disciplined or terminated, I now have to deal with a new person, which I may have to train and start all over again, or I might have to do more work. So there's a hesitancy of people who are coworkers to tattle on people who they perceive as being on marijuana. Even though the employee doesn't really want to work with a person who is on marijuana, they're loath to report them. He said, Gary, I don't really care that much if marijuana is in their system. I'm assuming it is. I need to staff my business. That's his priority. And it's a sobering reality right now, especially post-COVID, that I assume almost all of you out there who's listening to this presentation have staffing issues. How do you enforce strictly the non-use of marijuana and yet hire the people you need to hire, never mind the highest quality people? That is a daunting task. So a drug-free workplace may not be a reality or feasible. What are we talking about today primarily? We're talking about the THC component of marijuana. We are not talking about CBD, but THC, the psychoactive component. CBD is used for medicinal purposes. You see them sold everywhere. It doesn't have the psychoactive result as the THC. But a little footnote here: if you administer a drug test, there's a possibility that somebody who has not taken THC, at least not purposely, can still be positive for THC if they took CBD, because sometimes in CBD there are trace amounts of THC. We're going to talk about drug testing later, but most people, when they do drug testing, they do urine analysis, a urine test, and they determine a certain level of what I think it's 50 nanograms, and if there's 50 nanograms or more, it's a positive. Then they usually do a confirmatory test, and the confirmatory test is only 15 nanograms of content. Incidentally, employers who do drug testing do have an option to do a hair follicle test. Hair follicle tests are more precise. And we're going to be talking about this later, but jump into the gun. As you probably, most of you know, THC stays in your system for 30 days, at least for a urine test. It stays in a hair follicle for 90 days, just as a footnote. And we'll talk about that a little bit. So we're going to first talk about federal law. What you have to remember, and I think you know this, but federal law, marijuana is illegal. Okay? Very simple. Marijuana is under the Controlled Substances Act, considered a Schedule I. Under federal law, Schedule I drugs include heroin and LSD. So according to your government, and by the way, I'm not pro or against marijuana, I'm just telling you the facts. According to the United States government, marijuana is in the same category as heroin and LSD. What's going to be important to understand later, especially when we talk about the Americans with Disability Act, is Schedule I drugs do not implicate the ADA. So a Schedule I drug is not accepted for medical use, all right? And it's kind of common sense that heroin and LSD wouldn't be accepted for medical use. I know it's harder for us, for instance, in Massachusetts, who we have a law that basically says marijuana can be used for medicinal purposes. That is completely the opposite of federal law, which says Schedule I drugs are not accepted for medical use. As an aside, that last bullet says CBD oils are classified as a Schedule 5 and approved by the FDA, meaning mildly regulated, not really of a concern, and that's in the same category as Robitussin. I got to wake up my mouse, go to the next slide, sorry. All right, so under the federal law is the Department of Transportation. Now, there are many federal laws that govern marijuana. We're only going to hit a few today. For instance, we're not going to talk about the laws that affect aviation or the laws that NASA has to abide by. But many of you in the audience today have to follow the DOT guidelines. So the DOT basically says for positions that are regulated by the DOT, such as a CDL licenses, you have to follow what's called the Omnibus Transportation Employee Testing Act. What that means is you're going to do drug testing. You're going to do drug testing for all CDL operators. The DOT, right? So right now we're talking federal law. DOT under federal law doesn't care if you have a medical marijuana card. Now, it's not a prescription, right? Medical marijuana is not a prescription. It's basically a card. It's a certification of sorts. The DOT basically says, hey, it's unacceptable for any safety-sensitive employee subject to drug testing under our rules to use marijuana. So we don't care why you're using it. We don't care if it's legal in your state. If you test positive, it's a violation of DOT regulations. So they don't recognize medical marijuana if you have a positive drug test. The DOT requires all covered employees to be tested for cannabis, marijuana, and to fail a drug test means you have to remove that employee from the job. So it's a truck driver and he fails the drug test, you have to remove that person immediately from driving the truck. Makes sense. Well, it makes sense following the DOT guidelines. If you weren't under DOT guidelines, there's a question whether it really makes sense, especially if the employee said, yeah, I admit it, but it was 30 days ago when I took it. I'm not under any psychoactive effect right now. DOT doesn't care. You test a positive, it's an automatic disqualification. You're going to be removed from the sensitive or the safety sensitive position. The employee cannot perform that position that he was once in, CDL operator, until he fulfills certain obligations. What's interesting is the DOT does not require removal of the employee. So you don't have to say, you could terminate the employee under your own guidelines, but DOT doesn't require that. The other federal law is the Drug-Free Workplace Act. The acronym you might see later in the presentation, I put as DFWA. This act applies to federal contractors and grant recipients. So there are clients in the audience who are federal contractors and or grant recipients. And what that means is your handbook has to have this protection, if you will, for your employees, because it's a mandate. When you're given a federal contract, there are conditions attached to the federal contract. And one of the conditions is you're going to abide by the Drug-Free Workplace Act. The Drug-Free Workplace Act is a zero tolerance policy. Zero tolerance, meaning, you test for marijuana positive, you can't work. You cannot have a positive screen. But it doesn't actually require drug testing, and therefore anybody who falls under the Drug-Free Workplace Act, if they could avoid drug testing, frankly, they don't do it because they will simply lose employees. It's just I consider it like an educational act. You're supposed to educate your employees. You're supposed to make what's called a good faith effort to maintain a drug-free workplace. And you do that by education. Education by putting it in your policy, by perhaps a presentation, other materials about drug use, and of course, offering an EAP program. So what did we just basically talk about? Impairment, by the way, can be prohibited in the workplace. Let's just get that clear. Regardless of whether you think somebody's on marijuana or not, alcohol or not, if they are impaired, they can be prohibited from working, even if they're on medicinal marijuana. It's akin to having a no alcohol policy, right? You don't allow somebody to work if you believe they're intoxicated. Same thing with marijuana. If you believe that they're high, whether you're right or wrong, you could tell that person, you're not working today. The law does not place restrictions on employers' right to administer a drug test. So the federal law, even though it mandates that marijuana is illegal, the DOT doesn't require drug tests. It doesn't say to the employer, you don't have to do. In other words, for those instances where the law doesn't require a drug test, you as an employer can still do a drug test if you wanted to. Most employers, as we'll discuss later, are probably not going to do that. The Americans with Disability Act. Anybody who has 15 or more employees is familiar with the Americans with Disability Act, or at least you should be, because it applies to you if you have more than 15 employees. And if you have less than 15 employees, you're not off the hook. There's Massachusetts law that mimics the ADA, but the ADA is in essence trying to prevent discrimination against applicants or employees who have disabilities. And then the question always becomes, well, if I'm taking medicinal marijuana and I have a disability, shouldn't I get protection under the Americans with Disability Act? Well, remember that first slide? I said, remember this? I said Schedule 1 under the Controlled Substances Act, Schedule 1 drugs are not recognized for medical purposes. Think about the ADA. So the third bullet here, the ADA does not protect the current use of illegal drugs. The federal law considers marijuana an illegal drug. The Americans with Disability Act is a federal law. Therefore, the Americans with Disability Act does not protect anybody on marijuana, whether it's recreational, especially if it's recreational, but even if it's for medicinal purposes. Even if I have my card, I can't tell the employer, hey, I'm granted protection under the ADA. Again, employers, you're not off the hook because you're in Massachusetts, and Massachusetts is a little bit different. But the analysis under the ADA ends up being irrelevant because the ADA does not protect the employee for medical marijuana use. It does protect, on an aside, the last bullet does say, hey, it does protect the current use of legal drugs, likely including CBD, but legal drugs in the eyes of the federal government, marijuana is considered an illegal drug in the eyes of the federal government. Therefore, the Americans with Disability Act does not protect those on marijuana, even for medicinal purposes. But then we come to Massachusetts. Massachusetts, and I put the word Rhode Island in, or the state of Rhode Island as well, because, well, a lot of you do work in Rhode Island and it's next door to us. So in Massachusetts and Rhode Island, you have to engage in what's called the interactive process to determine whether medical marijuana can be accommodated, which can include discounting a positive test. What does that mean? It means, and I'm going to go through this in the next few slides, but if somebody has a medical marijuana card in Massachusetts, you cannot automatically disqualify that person. Under the ADA, you could, but in Massachusetts, you can't. You have to begin the analysis under the ADA, which begins with the interactive process. Also, I put there, it says, which can include discounting the positive test for marijuana. So an accommodation could be to somebody, we're not going to use the positive test against you, which would normally be disqualification from employment. So Massachusetts has a completely different standard than that in the federal law. In Massachusetts, an employer cannot rely on a zero tolerance drug policy. It's different than the federal law. If you were somehow a solely federal employer, you can. Recreational marijuana, on the other hand, does not require employers to accommodate anything. All right. So there's no protection for recreational marijuana use. Marijuana use for recreational purposes is treated under the law in Massachusetts the same way as you would for alcohol. So in Massachusetts, when it was like a 2012, I should have put the year in here, but I think it was around 2012 when the law passed that marijuana could be used for medicinal purposes. The law had in it the language, there should be no punishment under state law for qualifying patients for the medical use of marijuana. There was kind of a question mark what that means. And in the case down below in 2017, Barbudo versus Advantage Sales and Marketing solved that question. Hold on. That case was about a female employee who was applying to work for Advantage Sales and Marketing. It's a marketing firm, and her position was not a safety sensitive position. All right, we're going to talk about what a safety sensitive position is a little bit later, but just know her position was simply marketing, and it was not deemed a safety sensitive position. She applied for the job, and she knew there was going to be a pre-drug screening before she actually began work. She was up front. She says, I have something where I have a medical marijuana card. What she had was Crohn's disease. And it was shown later, you know, you look at the facts of the case, where she's tried a lot of medications and a lot of different medical remedies, and medical marijuana worked best for her. So long story short, she was upfront and told her employer, I probably will test positive. I'm on medical marijuana. And they first assured her, no worries. She starts day one, she works. She finishes the day. Later, they say, hey, you tested positive for marijuana. She says, I thought that would happen. I told you in advance that likely would happen, but you told me not to worry. Apparently, somebody else up the food chain said, terminate her. So she was terminated. They first filed at the MCAD for discrimination based on disability. Then the attorney withdrew the case and filed it in Superior Court. The employer, just kind of, I find this a little interesting. The employer successfully dismissed the case, said, hey, this is medical marijuana, this isn't protected, and the judge agreed. The plaintiff, Barbudo, appealed it, and it went to the Supreme Judicial Court of Massachusetts, and the Supreme Judicial Court said, you can't, it didn't ultimately decide the issue, but it basically says you can't discriminate in Massachusetts against somebody who's using medical marijuana. They are deemed a disabled person, and they get all the protections under Massachusetts disability laws. So Massachusetts has laws that are akin, similar, and treated the same, in essence, as the Americans with Disability Act, but for Massachusetts. And it applies for those who have 6 or more employees. So if you have 6 or more employees in Massachusetts, the Massachusetts disability law applies. Really, it's the Massachusetts discrimination law, chapter 151B, but it applies. And then you have to follow the rubric of what one does when they reveal that they have a need for accommodation. So that case recognized that allowing off-site use, because there's no law that says you have to allow somebody to use marijuana, whether it's for medicinal purposes or not, at work. This lady didn't use it at work. She used it at home, at night. Whenever she used it, wasn't at work. So the law says, hey, allowing off-site use, i.e. her home, might be a permissible accommodation, right? The court's not deciding whether the accommodations appropriate or not, because accommodations are a case-by-case basis, determining the facts of the case. So under disability laws, they said, no, you can't say that somebody with a marijuana card is automatically disqualified. You have to go through the proper interactive dialogue. And interactive dialogue is a process. So ultimately, that case made it so that in Massachusetts, an employer does not have to require or can't eliminate the off-duty use of medical marijuana. Instead, employers may, depending on the circumstances of the job, and we're going to talk about that, to allow it as an accommodation in certain circumstances. In the case at hand, her job was not a safety sensitive job. It was a position where, if she was under the influence of marijuana, strike that. It wasn't a case in which she was, necessarily under the influence of marijuana, where she was showing overt signs of under the influence. She just had it in her system. And actually, we're going to talk about later how there really is no mechanism right now to determine levels of marijuana and what level affects one where they're kind of intoxicated under the law. If she had a safety sensitive job, it would be a different result, and we're going to go over that. So the decision ruled that the disability discrimination laws may require an employer to waive its drug use policy as an accommodation for those who use medical marijuana outside of work. What that basically means is in Massachusetts, you really can't have a zero tolerance policy which would prevent somebody from using medical marijuana as a way to help them with their disability. If you could still have a zero tolerance, but you have to make an exception, most likely, for that person with the medical marijuana card under certain circumstances, which we're going to go over in a second. All right, so if you don't know what the interactive process is, one, shame on you. Two, we're going to talk about it right now. It's a dialogue. So the Americans with Disability Act came out back in like 1991, 1992, and it basically said, hey, you have a duty to accommodate those with disability. So, run with it, employers. And then employers really didn't know how to handle it. So I think it was around 2007, the ADAAA came out, the Americans with Disability Act Amendment Act, which basically created or reaffirmed some of the cases that were coming out that says, hey, employer, you have to have a true dialogue with the employee to determine whether an accommodation can be made. And this is where a lot of my employers go wrong, because they say, hey, Gary, this is going on. We can't accommodate that. They come to the conclusion so quickly, we can't make that accommodation. If you make that conclusion before having a dialogue with the employee, that is a violation of the disability law. That in itself is a wrong. So even though you may have come to the same conclusion that you can't accommodate, you have to jump through the hoop. And anybody who's a client of mine knows, I always say that, you got to jump through the hoops, because jumping through the hoop is a document it documents your trail of attempting to work it out with the employee before you ultimately conclude, should you ultimately conclude, that you can't do the accommodation. So you got to always have the interactive process. Don't forget, now this would kick in under this context if you have somebody who tests positive for marijuana, if you're doing a drug test, and you know that they are on a medical marijuana card. Now, again, there are exceptions, and we're going to talk about the exceptions, but this is only under Massachusetts law. Remember, the ADA doesn't apply. There is no federal law that mandates the interactive dialogue. Well, there is, but it's not applicable to marijuana. So if you're a Massachusetts employer and you have to accommodate or at least start the interactive process, what are the exceptions that would allow an employer to say we cannot accommodate? Well, there are two primary exceptions. One is if the job is safety sensitive, and we're going to discuss that in a couple of slides later, what that really means. Oh, and by the way, I think you were already told you're going to get a copy of all these slides, so you don't have to worry about writing all this stuff down. So if the job is safety sensitive, the forklift driver, you have a chainsaw operator who cuts down trees, you have a driver who's constantly driving, those are safety sensitive positions. You don't have to accommodate the medical marijuana. Undue hardship. Undue hardships have to be looked at on a case-by-case basis. They look at the organization, they look at the financial hardship. A violation or an exception to accommodation could be whether you have a contract with the federal government or the drug-free workplace guidelines that you have to follow because of your federal grant or federal contract. So there are exceptions to your need to accommodate. Slide have examples, such as driving a motor vehicle, working with power tools, operating equipment, working on a scaffold or ladder, construction industry, security guard, any job requiring the carrying of a gun or knife, or you think of woodworking with power tools. The clerk of your business, the secretary of your business, the architect of your business are not safety sensitive positions. So again, why is a safety sensitive position relevant? Because if you're looking not to accommodate somebody, if you don't have an undue hardship, it would have to be a safety sensitive position. Recommend that job descriptions include something that notes whether that job is a safety sensitive position, whether that job could impair or pose a safety risk to the individual or to a third party. And it might, even though you might not have drug testing company-wide, or you might not even have drug testing at the present, but contemplating it, there's nothing wrong with having in the job description a notice that there could potentially be drug testing for that safety sensitive position. You have it in there. Later in time, you could adopt a policy of drug testing. You don't have to change the job description. All right. Next slide. So this is a little redundant of what I already talked about, that under the ADA, a person who's currently engaging in any illegal drugs, that's not a qualified individual with a disability. And as indicated by the Federal Controlled Substances Act, there's no protection for those using marijuana, even for medicinal purposes. So even if I have a valid Massachusetts card, I get no protection under the ADA. So again, any accommodation is not under the ADA, it would be under state law. So in summary, when you're dealing with an issue where somebody has a medical marijuana card in Massachusetts, you have to engage in the interactive process. Hey, Mary, we understand that you're on a medical marijuana card. What is it that you need for accommodation here? So you set the practice. Sometimes there's no request at all, meaning that person doesn't really need any accommodation other than their allowance, if you will, failing the drug test. So that's an accommodation. Okay, we're not going to fire you because you failed the drug test, which is uniformly enforced everywhere else in the company. We won't apply that against you. So then you evaluate. Okay, so this person is going to work with us. Is she going to work in a safety sensitive position? What are the essential functions of the job? Does she need accommodation? Can we have her working knowing that she has marijuana in her system? And again, if it's not a safety sensitive position, you might have another fallback, which is the undue hardship. So is it an undue hardship for us to have this person work for us, knowing that she is a user of medical marijuana? It can't simply be, yeah, we don't trust their work. Yeah, we don't think that's a good idea. You have to have a basis under the law. The only bases right now under the law are if it's a safety sensitive position and if it's an undue hardship. Undue hardship, again, can be, well, having her work for us is in direct violation of our federal contract, of our grant. It can't be, we want to have a zero tolerance drug policy and we follow federal law. You can't make that mistake in Massachusetts. That was what the case I just talked about. The defendant, technically the defendant was a California company and they're also doing business in Massachusetts. And their defense was, we follow federal law. You can't just sit on your laurels and say, oh, we follow federal law. We have a zero tolerance. No, you're in Massachusetts. You got to follow Massachusetts law as well. And Massachusetts law allows for reasonable accommodation. So let's talk about drug testing. Just want to see how we looking at time. Ooh. All right. So we know many companies do pre-employment drug testing. Some do random drug testing. Some do post-accident drug testing. What are some other drug testing? Reasonable suspicion drug testing. So before marijuana came legal, I had clients approach me, we're talking over 10 years ago, approach me saying, Gary, we can't find enough, it was in the trade industry. We can't find enough plumbers, whatever it is, to work. And when we test them and they test positive for marijuana, we still want to keep them. You know, can we do that? So we started having drug testing exclude marijuana even before it became illegal. You have to do your own balancing act. So for pre-employment, many companies do pre-employment, and you could do pre-employment because, well, there's no case on point, but I believe the way the law works now is you can, contingent upon a job, do a pre-employment drug test. And if they test positive, you don't have to hire. If they test positive for marijuana and they have a card, you have to go through the not the ADA process. You have to go through the Massachusetts disability law process, the interactive dialogue. If they test positive and it's recreational drug, right? They don't have a card and they just test positive. Well, you got to figure out what your policy is going to be. Pre-employment, post-employment, I would argue it's a different story. And I'm not sure if I even have a slide on that, but if not, I'll just talk about it. Okay, I do. So this is a case, Webster versus Motorola. It's actually a 1990s case that talks about drug testing. And it says, hey, you can't just drug test randomly everybody. And I know employees have privacy interests. All right. So whether you realize it or not, the taking of urine and testing of urine for drugs is an invasion of my privacy. Of course, an employer can invade the privacy if their interests outweigh the privacy interests. So that's why the case law says, hey, you gotta look at this as a case-by-case basis. Does the employer interest outweigh the privacy interests of the employee? And what would outweigh the privacy interest? Well, I think of the safety sensitive positions. So if I have a tree company, I cut down trees. Well, anybody who uses a chainsaw, to me, is a safety sensitive, not to me, I think to everybody, it's a safety sensitive position. So I could randomly drug test, if I wanted to have a policy, those individuals using and operating a chainsaw. However, I cannot use that same drug test for the clerk in the office who sits behind the desk primarily and uses the computer, because the rational basis for drug testing that clerk is what? I just want to know if they are taking drugs and again, I'm focusing on this presentation's on marijuana, in what, for what purpose? Meaning it's not going to affect their job. I know some will argue, yes, it will. The law basically says you look at it on a case-by-case basis, and you're only allowed to randomly drug test those that are in basically a job sensitive, safety sensitive position. So this case basically said, the Webster case, that an employer was permitted to randomly test a salesperson because that person had to drive the company vehicle. And the company had an interest in ensuring that that driver was not impaired by drugs or alcohol. That same company tried to test a clerk, and the court said, hey, that was not legitimately applied to that clerk. Oh, and it was a technical writer, because that employee did not implicate the same safety issues. So you cannot have a drug testing policy and say, oh, it applies to everybody. It almost sounds very fair, right? It sounds very fair, non-discriminatory. It applies to everybody, but you can't do it once they're working. You have to do it based on their job protection, their job function. Kind of a fun fact here, there's no reliable metric for determining when a particular level of THC from marijuana impairs the user and for how long it remains impaired. As I indicated, through a urine test, it stays in your system for 30 days, hair follicle test, 90 days. So don't tell me that if I use marijuana 80 days ago, that it's, affecting me today in any way, shape, or form, but yet I will fail that drug test if it's through my hair follicle. And according to the DOT, not that we're going to go backwards in time in this presentation, but they would say, I'm disqualified. I can't do the safety sensitive position. So kind of my aside, what to me that would mean is, over time, as the states are becoming more and more proactive, allowing recreational use, medical marijuana use, the federal government, which is lagging obviously far, to take this Controlled Substances Act and calling it a Schedule 1 right now, they're gonna have to call it something else, because let's face it, it's not in the same category as LSD and heroin. But until then, well, it is. So we talked about this in the beginning, how marijuana affects you. We don't need to go over it again. I think everybody knows how marijuana affects an individual. I know some will disagree. And of course, it's a function of how long ago you took it before these actually, these impairments last, right? California, this is interesting. So I just thought I'd throw this in as an aside, even though it has nothing to do with Massachusetts. California signed into law something recently that goes into effect next January 2024 that prohibits discrimination in hiring or allowing termination or other employment decisions based on one's consumption of recreational marijuana off the job. So it's becoming even more, I hate to say marijuana is becoming employer friendly, but now there are laws in other states protecting the recreational use and saying you cannot prohibit recreational use. Let me clarify that. Of course, you can prevent somebody using or possessing marijuana in your workplace, right? We're saying that what's coming is just because they test positive in your system, in their system, we already have the disability protections now in Massachusetts for medicinal use. Right now, the DOT still prohibits it as an illegal drug, but come another 5 years, I think that's all going to change. So policy considerations, your company, you're going to have to just relook at some of your policies. You might have already done this, but you got to look at, well, what is the behavior that we're trying to prohibit? I think you should address, if you haven't done so already in your policy, marijuana specifically, and what situations you might have drug testing. If you do drug testing, you can't just randomly do drug testing, right? Every so often I have somebody who says, hey, Gary, I think so-and-so is doing drugs. What should we do? We want to send them to a test. I'm like, do you have a drug testing policy? No. I'm like, well, why do you think they're on drugs? Well, I think so. Well, has the person who thought that been trained, the management? No. You can't just randomly send somebody for a drug testing test, which I know some employers have done, without a real drug testing policy. I mean, when I say real, I mean, you got to give people the policy ahead of time. Hey, you're subject to random drug tests, or you're subject to drug testing upon reasonable suspicion. And if you have that, you could actually have training for your management to determine what the heck is reasonable suspicion when somebody's on drugs. All right, I'm going off on a tangent, but you got to note in your policies what the potential for discipline is. Is it simply a written reprimand, or is it going to be termination? And you got to basically talk about, or you got to make sure that it's applied across the board, not in a discriminatory manner. Other policy considerations are, well, your drug-free workplace. Many companies historically have a, this is a drug-free workplace. Well, those policies were great before medicinal marijuana came around in Massachusetts, but you really, I don't know if those policies are going to really exist anymore. Okay. Now, illegal drugs, we're not talking about, right? We're not talking about, any, heroin, mushrooms, I don't know, whatever drugs you can think of. We're not talking about other illegal drugs. Of course, you can have those drugs prohibited from either being used or consumed or possessed. I'm talking about marijuana. So you got to consider your policies on whether it's pre-employment testing, reasonable suspicion, post-accident, and being under the influence of a drug. Yeah, I mean, zero tolerance policy, again, I think is a thing of the past. And oops, whatever happened to this slide? The next slide here. I don't know what that slide is. Oh, I know what that slide is, even though you can't read it. There's a bill in Massachusetts. It's been in Massachusetts for the last couple of years. It's basically trying to prohibit employers from taking any action against employees who have marijuana in the system. So you do a pre-employment test for somebody. They want to, when I say they, those people who are introducing the bill want you as the employer to be prohibited from taking any action whatsoever if they have marijuana as a positive. All right, so questions and answers. I see that there's a bunch of questions in the chat room. I don't know if somebody
Gary, I got
read
it.
them out.
Gary, let's start with this. The first one, which I think is more simple. For the 6 or more employees, is that FTEs or just the number of actual employees you have, part-time or otherwise?
All right, but how is it? I'm sorry. Is the question how do you count the employees? It's everybody.
Yeah.
So whether they're part-time, full-time, but listen, don't. All right. So excellent question, whoever asked that, because you're right. First of all, there's an issue on how do you count the employees. I filed motion to dismiss, alleging that a company only had 5 employees and wasn't subject to the Massachusetts law. However, Massachusetts does have civil right laws, equal right protections. So there's a possibility, even if you have under 6, that you could also be charged with violating those laws. But to answer your question, 6 or more, that's not just full-time employees, it's full-time, part-time as well, and any other type of seasonal employee. And I think there's a rubric that they use, and they might actually look back the last 3 years to see on average how many employees you have. And it includes the principal, right? You say, hey, I'm the owner, it includes you.
Okay, if someone comes back from lunch break and smells of marijuana, how can we address this without opening us up for discrimination? We cannot randomly drug test. There's no policy for that, and the position is not a safety concern.
It's like anything else. So first of all, you could address that under your hygiene policy. Most companies have a certain policy concerning hygiene. All right, hygiene includes sense of smell. So you can, it starts as a stern warning, at least. Write them up under the Hygiene Act policy, and that's probably the way I would approach it, because inevitably they probably would do it again. Now, if they are in a safety sensitive position and you think and you look at them that they're acting in a particular way, of course you have the right, just like if they were under the influence of alcohol, to dismiss them, send them home. You could even terminate them. If they don't have a medical marijuana card, you could terminate them. You might lose unemployment, if that's a concern. But we still have the rights to terminate employees here. especially if they're not on a medical marijuana card.
Thank you. So what if an employee receives a mileage allowance for driving their personal vehicles?
What's the question? Yeah, if, I mean, I don't know what if, I don't think that changes anything I said.
Okay.
Gary, this is Rick. I put that one in there.
No wonder why it was an incoherent question. No, I'm
Thank
joking,
you very,
joking.
very much. Gary, I'd put that in there because you had mentioned the specific case of driving a company vehicle. And whether it makes any difference whether one is driving a company vehicle.
No,
or
it makes no,
their own
it makes
vehicle.
no difference if you're driving a company vehicle or not. And in fact, if I said company vehicle, I could have said company or private in that context.
Okay.
That the individual is operating for the company driving. So if you're under the hourly payroll, if you will, if you're driving, whether it's your own vehicle or company vehicle, it's the same.
Thank you.
So Gary, Kim asks, can you speak to customers under the influence or possibly have another webinar for that?
Customers, I can't, how is that a whole webinar? Can I speak to customers under the influence? That's interesting. So if somebody, well, listen, you have the right as an employer, especially if it's like, I'll use McDonald's, right? Because McDonald's is the one that's public. In other words, the public is allowed to enter McDonald's. McDonald's can, whether you recognize it or not, refuse to service anybody. They just can't do so in a discriminatory manner. There's the MCAD has jurisdiction. I pursued one of these cases once. I can't think for the life of me what it's called. But basically, they can't prohibit, obviously, a certain class of people going in. They can't prohibit, oh, we're only going to allow people over the age of, so-and-so into our doors. But if somebody's under the influence and they want to refuse them, there's no issues there. You can refuse customers service if you feel that they are under the influence. That might not be answering your question if that's, but you can just call me up and I'll try to help you out there.
Well,
Hey, I saw somebody say I kept on freezing up. Did I freeze up a lot during this presentation?
a couple times you did, yes, but there was,
Yeah.
most of them were kind of short, but you did freeze
Yeah.
up a couple times.
Was I at least in a good posture when I did? All right.
So Gary, thank you very much. Before we go, everybody, I've got, Katie is going to put a poll up, and it's a poll. It's a very short poll. I'm serious when I say it's a very
It
short
says, did
poll.
Gary suck or not? No, only joking.
We're going to say Gary was great,
There you go.
and we're gonna make that a unilateral feeling.
Excellent.
But and we do appreciate it, Gary. But if everybody would please hang in there and do the poll, just answer the questions real quickly. We would really appreciate it. We just want to get our arms around.
So I'll answer this. Presentate. I personally don't like Zoom presentations. All right. The way my screen is set up, whether you realize it or not, I can't see anybody. I don't know reactions. I don't know if it's going well or not. And if I see somebody normally in an audience that looks inquisitive or has their hand up, we'll address it then and there. So I find a Zoom presentation where I'm doing nonstop talking difficult and not as fun. So I'd rather do them in person myself.
Not that you want to influence the poll or anything, right?
Not that I want to influence the poll. No, absolutely not. Maybe a lot of people don't want to see the poll actually only says, 8% in person. Apparently to me, that means a lot of people don't want to see me in person. I take no offense. It's okay.
Well, thank you,
Gary-
everybody. Thank you, Gary, and thank you, everybody, for coming. This is a great topic, and this is a topic I suspect it will be addressing again in the near future because it's so important, and it really does change how people have to operate their business.
Yeah, the problem is it's huge, right? So there are so many smaller components drug testing is a whole presentation in and of itself. So it's just a lot of information. That's all. All right, so I'm going to stop sharing.
Thank you very much, Gary, and thank you everyone for coming. We really appreciate it, and have a great rest of your afternoon. Thank you again.
All right, thank you, everyone.
Thank you.
Katie, stay on.